Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, listeners, learners, officers, officials, respected doctors and directors, honorable ministers and managers, honorable advocates, advisors, administrators and advisors, the most honorable present Commissioner Prof.Dr.RKS from USA, heartily cordially welcome. It is really nice time, nice place, nice session today. You are listening YouTube channel Prayer Creators. India to abroad, what is happening? A lot of changes we see around the world in nation. Behind them, man's nature does matter. So let us go through, let us discuss on that basis. Jurisprudence is the eye of law. Let us explain this statement and discuss the value and utility of jurisprudence. Jurisprudence is the eye of law. Lord J. Lasky called jurisprudence is the eye of law. The statement of Lasky is correct. Eyes have very much importance for human body. Without eyes, the life is very miserable. The same condition lies with jurisprudence. Without the knowledge of jurisprudence, the study of law is incomplete and unclear. Jurisprudence is such a key of law which uncovers many hiding parts of law and solves many knotty problems. As the knowledge of grammar is necessary for the study of language, likewise, the knowledge of jurisprudence is essential for the study of law. The studying jurisprudence is not only necessary for students but also for lawyers, judges, lawmakers, politicians, legislators, administrators, etc. The jurisprudence is very important in normal course of life also. The importance of jurisprudence can be studied under study of jurisprudence motivates meditativeness of the mind and sharpens it. The famous lawyer Dicey speaks that jurisprudence thinks over human attitude in relation to social science. Therefore, its study provides an opportunity Therefore, its study provides an opportunity to uplift the life of lawyers. It is true, jurisprudence is a principal study of law. But it does not mean that there is no practical importance of it. It has true importance in reference to country, time, and situations. Salman is of the view that with the development of generalization, science and mathematics have been developed by which various problems have been resolved easily. In his view, generalization in the area of law in an indication of reforms. Salman, while the right in respect of a property after certain time by way of adverse possession, then study of jurisprudence becomes important in reference to determination of necessary elements for possession. Jurisprudence not only performs administration of justice by law of legal systems, but it also constructs just society by way of new principles, thoughts and expoundings. Jurisprudence gives knowledge of principal grounds of fundamental notions of various schools of law, along with interrelation among them. The study of jurisprudence is useful with an academic view. The logical power of lawyers develops with logical analysis of legal concepts, which aid in solving a problem. Study of jurisprudence develops personality. The study of jurisprudence inspires us to refine the talent and encourage open mind. Buckland states that if a person is of open mind, he may be successful in developing his own philosophy. A person with the capacity to interpret the problems with open mind may be a talented lawyer like a doctor or sculptor. Study of jurisprudence develops the skill of adjustment in accordance with new situation. Fillmore has to say that the science of jurisprudence is of so high a level that its knowledge covers life with concepts and notions. solutions of problems in solving intricacies of law and complications of human relation may be sought in the jurisprudence. This is the reason that jurisprudence is called the grammar of law. In Consumer Education and Research Center versus Union of India 1995 3 8 CC 262, Justice Ramaswamy had jurisprudence was light on fundamental principles and thoughts of law. The main object of jurisprudence is to make available the social to the person. In the case of Bash Sugar Mills versus State of Uttar Pradesh, AIR 1979, it has been held that use of jurisprudence should make to remove poverty, ignorance, helplessness, etc. of the persons of India, so that a welfare state, as per imagination of constitution makers, would be established. So the importance of study of jurisprudence is continuously increasing at the present time. Today, origin of concepts like reforms in jail administration, humanity's attitude with prisoners, right of living with human dignity, public interest rate, free legal assistance, etc. is from new jurisprudential view. It is jurisprudence who played an important role in raising the law related to environment protection, consumer protection, child marriage and dowry prohibition. Let's discuss the imperative theory of law propounded by Austin. Let's critically examine Austin's imperative theory of law and point out its contemporary relevance. Let's examine critically the definition of law as given by Austin. Austin was a student of Bentham, the famous jurist of England. John Austin is considered to be leader. In the content of state, his period was from 1790 to 1859 AD. He made a relevant attempt to provide practical form to law by following an analytical approach. According to him, law is a collection of such rules which one prudent man frames from the guidelines of another prudent man over whom he has the sovereignty. Austin, while defining positive law, said that this law is group of such orders which is sovereign in an independent political society frame to determine the behavior of public. Thus Austin gave the definition of law as law is the command of someone. This definition shows that law is different from justice. According to his view, law is right dependent on proper, improper, but is dependent on the orders of sovereign. Law is vested in the power of sovereign. It is the reason that the principles of Austin is called imperative theory of law. What are the essential elements of imperative theory? The imperative theory of law by Austin has mainly three essential elements. One is sovereign power, two is command, and three is sanction. What is sovereign power? According to Austin, law is the command of sovereign. Sovereign power has two symptoms. One is it should be supreme. For example, it should not be governed by an external power. And two is it should be of such nature that its orders are voluntarily followed by the public. The sovereignty of Austin has two nations, positive and negative. The positive nature is that the command of sovereign should be habitually followed by society, public or majority. The negative character is that the sovereign is not habitual of following over of any other power equivalent to it. Thus it is clear that sovereignty of Austin is such that it is supreme. No one is above it and his orders are followed by the general public as a habit. What is command? Austin has had to be command over sovereign. Command is the expression of will of the state, which requires public to do an act or follow the order. The expression of such will is not in form of praise, rather as an order. Such command are of two types. One is general command and two is particular or occasional command. What is general command? It means such a command which is issued over all persons, communities or classes in an equivalent way, and it remains in force till it is cancelled or repealed. In other words, it can be said that general command compels all communities or classes to do or abstain from doing an act. In its institution, it thus was has prohibited the export, import of any particular thing by an order. Such order shall have the effect of law and shall remain in force till it has not been withdrawn. What is occasional command? It is also called occasional command. It means such a command which is issued in respect of certain particular person, classes or communities for every time, or in respect of all person, classes or communities for certain time. In other words, it can be said that occasional command is that command which requires to do or abstain from doing any particular act or requires any particular person, class or community to do or abstain from doing an act. Thus, particularly could be related to any act of any person, class or community. In brief, it can be said that occasional command can be issued for certain time in respect to one person, class or community, etc. Can be issued in respect to any person, class or community forever. What is sanction? The third important element of imperative theory of Austin is sanction. Austin viewed that the order of sovereign only cannot become law, it requires that there must be some sanction behind it, like fear of sanction is required. Until there is no provision of punishment for those who do not follow the orders, till then the order cannot take place of law. The order and sanction only creates the positive law. Thus the coexistence of sovereign command and sanction is the imperative theory of Austin, and this ratifies the concept that law is the command of sovereign. In its criticism, we can analyze the imperative theory of Austin has been criticized by the fellows of historical school, Sir Henry Maine and Savigny. Henry Maine said that the principle of imperative law does not apply to ancient communities because law does not always relate to sovereign power. Similarly, Savigny had called the sovereign power of Austin as baseless. Savigny viewed that law is the rule of act and conduct of human beings, which are recognized by national customs. Bryce also criticized the imperative theory of Austin by saying that if law is considered to be the command of sovereign, the law cannot exist without sovereign. Bryce said that law existed in society even when there was no existence of sovereign power. We know God of views that international law is a law even when there is no power behind it. Thus, various jurists criticize the imperative theory of Austin in their own way. The ground of criticism had been following. The definition of law by Austin, that law is command of sovereign ignores the traditions and customs. The imperative theory of law by Austin has no place for just-made law. Austin had made a mistake of considering international law as only world law. This belief of Austin is wrong, but implementation of law requires sanction. Sometimes the work of sanction is performed by public opinion. The concept of sovereign by Austin does not apply in the democratic system. The view of Austin cannot be accepted that law has no relation to morality. In fact, the rights, beliefs, liabilities, thought, etc. are based on morality. The view of Austin is baseless that there is no relation between law and justice. Even with all this, the importance of imperative theory of Austin cannot be ignored. Patten said that the one benefit of the relation of law is sovereign by Austin has been that it avoided the situation of conflict between sovereign, for example, state and church. The one benefit of the relation of law is sovereign by Austin has been that it avoided the situation of conflict between sovereign, like state and church. Now it is clear that the power of law making is in sovereign only, not in the church. Church shall have only those powers which are provided to it by the state. The imperative theory of law became a source of inspiration for the future jurists. The analytical approach of law by Austin started a new chapter in their students. Let's explain Hans Kelsen's pure theory of law and discuss its relevancy in India. Legal theory and human rights philosophy. The pure theory of law, propounded by Kelsen, let's explain the main postulates of Kelsen's pure theory of law. What are its main criticisms Hans Kelsen is considered as head of Vienna School originated in creation of analytical thoughts of Bentham and Austin. The jurist of this school propounded pure theory of law in which the name of Kelsen is given. Pure theory of law of Kelsen was firstly published in Law Quarterly Review in the year 1924. In respect of pure theory of law, it has been said by Kelsen that pure theory of law is a principle of discriminative law, is general principle of law. In pure theory of law, Kelsen has made efforts to maintain the purity of law by extracting the elements of moral and chromatic for what is the law, not that what it ought to be. Essential elements of pure theory of law. Kelsen's pure theory of law is based on following elements. Pure theory of law should include only that part of knowledge which deals with law and should be free from all foreign elements. In other words, it may be said that the description of what is law should be there in principles of law and not what it ought to be. There is a difference between law and principles of law. Exposition of the principles of law should be in such a manner so that all subject matter may be presented through law. Principles of law should be implemented at all places and time in an equal manner, and they should not be within limits of place and time. Principle of law should be pure, it should be free from the effects of sociology, politics, ethics, history, etc. Jurisprudence is a normative science and not a natural science. Nature of principles of law is scientific and non-volitional. That is, it is a science, not an expression of desire or volition. Central point of pure theory of law. Origin of norms is considered as the central point of pure theory of law of Kelsen. According to him, the legal order is the legal order is pyramid of norms to stimulate the pure theory of law Kelsen. Firstly, one has to understand the difference between science and fundamental source of law. Base source of science is the knowledge of relation of work and reason, whereas base source of law is the knowledge of what ought to be in a situation. This ought have been checked as stolen by Kelsen. For example, if one breaks the law, then he ought to be punished. Thus, the crux of your theory of law of Kelsen that natural science is related to causality, whereas the law being social science is related with normality. Kelsen has also clarified the difference of ought to be legal and ought to be moral. According to him, ought to be legal may be obtained from external world appearance, ought to be moral may be obtained by personal perception and thoughts, ought to be legal in objective, whereas ought to be moral it's subjective. What is the importance of pure theory of law? It is being said that pure theory of law Kelsen has removed the mist due to analytical method upon law and propounded such a logical theory of law which can be implemented and any legal arrangement. Importance of Kelsen's theory of law is due to following reasons. This theory does not differ in state and the law. That is, there is no division between state and the law. Kelsen considered the state and law as two rights of an object. He had resolved the problem arisen before Austin that whether the constitutional law is to be recognized as law in practical or not. It is not necessary for the pure theory of law Kelsen that the form of law be imperative. which does not mean that according to Kelsen, sanction is not necessary. Sanction was required but not so much as considered by the Austin. In view of Kelsen, the law being not a command of individual sovereign as a merely imaginary decision. Kelsen considered the international law better than state law. Austin did not consider the international law as a law because there was a lack of sanction under the pure theory of law of Kelsen. The customary law has been recognized as positive law, whereas the Austin did not give any recognition to custom in his imperative theory of law. There is no difference between private and public law under pure theory of law of Kelsen. This criticism, pure theory of law of Kelsen, has been criticized by criticasters in their own manner. The main points of their criticisms are as under dualism between state and law was finished through the pure theory of law of Kelsen, which is not proper because the power of state becomes too limited due to it. Kelsen had finished the difference between private and public law to pure theory of law which was not proper and doing the same. The necessity of determinable of legal liability of state was also not taken care. To determine the powers of the authorities of a state is welfare state, these both laws should be necessarily distinct. By giving priority to international law upon law of state, Kelsen has opined the backdoor entry of natural law. Pure theory of law of Kelsen is a worthless exercise of which there is no practical importance in actual life. Some criticasters consider Kelsen as a logician living in imaginary world. Friedman had said up to the level that pure theory of law of Kelsen is unable to resolve the modern legal problems, even after pure theory of law of Kelsen is maintaining an important place in jurisprudence. Let's discuss the historical school of jurisprudence. The basic idea of Savigny and Henry Maines. What is Volkage's theory? Savigny's Volkage's theory in detail. In the various schools of jurisprudence, the National Law School comes at the top. This school was based on rationalism, which emphasized on the aim and object of law. It had no place for the history and development of law. Consequently, analytical positivist school originated as a reaction to this, and along with it originated the historical school. The followers of historical school were mainly Montesquieu, Locke, Hugo, Savigny, Henry May, Hegel, Euler, Spencer, Consta, Sergei Vinogradov, Frederick Pollock, etc. Montesquieu of France, 1989 to 1755, is considered to be the one who helped in the growth of historical school. He was the first jurist who, by his research, tried to prove that the nature of law depends on several natural and social facts, and other events have serious effect over law. Hence, law should be considered to be medium of fulfillment of country and circumstances, and therefore should be studied with historical approach. Montesquieu was of the opinion that the form of law also depends upon natural public consciousness. Formation of law is from cause and effect. According to Edmund Burke, in 1970, a book of Edmund Burke named Reflections on Revolution in France was published in which he propounded certain important political and philosophical principles while following the historical approach. Bach criticized the constitution law implemented in France after its revolution and said that instead of making any law on immortal principle, it should be provided an opportunity to develop naturally and on its own. Edmund Burke strongly believed that law was the result of continuous organic growth, hence it should be studied in historical background. According to Hugo, the period of Gustav Hugo is from 1768 to 1854. 1768 to 1844. Hugo was also of the view that there is no appropriateness of debated law. He believed that natural and organic growth of law is more relevant. Hugo believed that law changes its nature according to the language and conduct of a particular community, and therein it develops accordingly. The fact is that law is accepted by the public, regulated by the public itself and follows it. Savigny says the name of Savigny is taken as famous among the historical school. His approach had been effected by the Bach and Hugo. German jurist Friedrich Karl von Savigny got strong support due to violent political situation in Germany. At that time in Germany, different laws were prevailing in different places. Hence, after the war with Napoleon, the question of codification of law arose, but there were lot of obstruction in codification. The factual position is that the laws were prevailing there from the past and per local public's conduct and attitude without any interference of an outside agency. Hence, the work of renovation of them was extremely difficult. It was a situation of conflict between argument and customs. In such situations, Savigny exhorted the historical development of law based on customs and strongly opposed the codification of law, and it started the historical approach of law in this sense. Savigny can be called the founder of the historical approach. Principle of Volgist. Volgist theory is considered to be a milestone in the growth of historical schools. Savigny believed that law is not the collection of immortal principles and rules only, rather it is the expression of internal feelings and requirements of persons of any community and country. The origin of law has taken place from the mutual support of people. In its preliminary stage, law was an important part of human nature and conduct. The nature of law is dependent on the language, customs, traditions and structure. Savigny strongly believed that law is also developed along with the development of nation. When the spirit of nation grows, then their law also becomes active and effective. On the other hand, when a nation loses its nationality, then law dies none. Nation means such human community which is bounded by social, historical and geographical series. It is the reason that Savigny had called the law as world risk of general public and is known as theory of workplace. Savigny recognized that when obstruction arises in natural growth of law, then violence and anarchy occur in the country, and such situation is difficult and critical for the public. The basic principles of historical approach of Savigny are: law cannot be created, rather it involves among the general public. The development of law, like the growth of body, depends upon the organic theory. This development continues itself. The development of law has occurred from the ancient community to the modern law. It has happened due to fast social progress. The nature of law is neither universal nor has been applied at all places in an equivalent manner. Law changes according to the language and abilities of persons as per their country. The language or law of one country cannot be applied to another country. The law of one country is representative of people's spirit of that country. The actual sanction behind law is social pressure and public opinion. Savigny believed that the moral order of natural law cannot be accepted as sanction of law. While making law, the historical aspect of it is required to be considered, like it must be seen that what was the prior law on that subject and why is there need in it to alter, modify or amend. The nature of law is never static. It keeps on changing according to the people's spirit. It also continues to develop along with the development of the nation. It is said to the extent that like life, law is not static. Law is not static. Codification increases the chances of obstruction in the development of law. In its criticism, the Bollish theory of Savigny has been criticized by several theorists like, according to Dr. Allen, the view of Savigny is incorrect that law is the expression of law is the expression of the will of any particular society or community, because if it is so, then the Roman law, which is not the expression of Roman Europe, would have not been successful in whole Europe. The view of Savigny is also baseless that lawyers have important contribution to the development of law because they represent the view of public. Dr. Allen says that law is also developed by judges by way of precedents. This theory of Savigny is merely an idealistic fiction based on external factors. There are several laws which have developed not on expression of public's people's spirit but on the conflict of classes, like labor laws. Similarly, there are several laws which are based on the will of someone. They have no importance to people's spirit. Slavery is its good example. Savigny has ignored the power of creativity of legislation by providing clarity to custom. This is not proper. In spite of that, adequate support has been gained by the theoretical school from the Savigny theory. According to legal 1772 to 1831 laws, a strong supporter of philosophical school, he made the whole gist theory of Savigny as the central point of his theory. He believed that materialistic things go through the process of development. There is a continuous conflict between ego and superego of a being. A coordination between the two modes in human being on the path of development. Hegel believed that proper is actual and actual is proper. According to Kohler, 1849 to 1990, Guy's theory gave a new direction to the concepts of Hegel and Henry Maine. Kohler believed that law is always relative and is deeply affected by the civilization in which it has begun. Law always follows social civilization and its main aim is to achieve social progress. The main duty of law in respect of social development is to maintain legal and tradition and create new concepts as per the time. The duty of legislators, advocates, and judges is to maintain law according to time. According to Spencer, Herbert Spencer, 1820 to 1923, is supporter of that school in which development of law is believed to be dependent on organic growth. This supporter of this school viewed that humans change themselves according to the situation from time to time. This helped in organic growth of law. Sir Henry Maine says he was a famous jurist of England. He had deeply studied English, Roman and Hindu law. He had an unique contribution to the historical development of English. Historical of English development, English law. After deeply studying different laws, he emphasized on following comparative method of historical study of law. After comparative study of laws of different countries, Henry Maine laid down common conclusion in relation to development of law. After the comparative study of Roman law and Hindu law, he believed that society is either static or progressive. There is also difference in legal development in two types of societies. According to Sir Henry Maine, every society has to go through. In first stage, development of law starts with individual orders, and in such situation, the individual orders of king are considered to be a symbol of divine spirit. In second stage, such order takes form of custom. In third stage, the authority of king was usurped by certain limited person, and they only transmit the laws. In fourth stage, every class of society breaks revolution against lawmaker, which results in the codification of law. In fourth stage, the static society does not develop further, and the development of laws also is obstructed. Whereas in progressive society, the development of law is continuous to legal fiction, equity, and legislation. Sir Henry Maine strongly believed that law also changes along with social changes. As the life is not static, similarly, law is also not static. In preliminary society, whether static or progressive, the legal rights, duties, liabilities, privileges, etc. are determined on the basis of law. But as the society moves towards development, the importance of status reduces, and the determination of legal positions started happening on mutual agreement. This reformed the position of slaves in Rome. The position of women also became better, and the relations of master and servant were being determined by mutual agreements. Sir Henry Maine has also expressed his views regarding origin, development and source of society, and legal institution. Family is the primary stage of society. Several families combine to form tribe, and there occurs character of nation. The women in family have no independent existence of their own and remain under the power of head of the family. Personal law was based on status in which there was no place for rights of sons, daughters and women. They were required to perform their duties only. Sir Henry Maine accepted custom as a form of law and said that customary law arises from definite decision. What is the difference in view of Savigny and Henry Maine? Here it is important that Although Savigny and Sir Henry Maine are strong supporters of historical school, but still there is difference in their opinion. Like Sir Henry Maine did not accept the whole Pigeon's theory of Savigny and said that creative power of legislation is only acceptable. Savigny has given importance to custom, whereas Henry Maine has emphasized on codified law made by legislation along with the development of civilization. The whole peace theory of Savigny was in accordance to the internal spirit of German society, whereas the theory of Tom's status to contact by Henry Maine was in accordance to the situation of contemporary capital and industrial society along with being practical. Although there were differences in thoughts of Savigny and Henry Maine, but study of various legal systems were made on historical lines and caused them of many of the exaggeration of Savigny's theory and trust the course of thoughts of Savigny and Henry Maine. Pushta. According to Pushta was a follower and supporter of Savigny. Pushta's views were based on spiritual and thoughtful unity. Pushta believed that man had always an affinity to unity. His unity was not only geographical but also spiritual. The unanimity of human community is reflected from its general will. When there is conflict between individual will and general will, then law play an important role in removing it. Such law is enforced by the state, hence the development of both should be studied under historical background. According to Garg, the name of Garg is also taken with respect among the supporters of historical school. The central point of the theory of Garg was human organization. He believed that the personality of a man is dependent upon the recognition of state. He had made a relevant attempt to determine the progress of society and development of law on the ground of legal history and organization, power of human being. Garg was not the supporter of individualism but a strong supporter of collectivism. It is the reason that Garg is also called sociologist. Vinogradov had an important place among historical school spotters. He had given important place to public opinion and will of citizens in relation to law, not to the sanction of state. According to Pollock, in the series of historical school, Sir Frederick Pollock is also to be remembered ever. Pollock did not consider international law as mere positive morality, but treated it as a law proper, which was based on mutual relations of the state. According to Pollock, it is through international law that nations regulate their relations inter se and try to resolve their dispute amicably. Last but not the least, I would like to thank all my brothers and sisters, ladies and gentlemen, students, scholars, teacher, trainer, professor, professional, officer, official, listener, learner, respected doctors and directors, honorable ministers and managers, honorable advocates, advisors, administrative advisors, the most honorable President Modi ji. Thank you. Nice to see all of you. Thank you very much.